Mic check 1 2, mic check 1 2 3. Good morning, everyone. The time is 9:15. We'll be getting started here shortly. This is our first broadcast test for audio for captions on our YouTube channel. For those that are listening online or joining us online, please make sure that your mic is unmuted when requested to speak on your turn. For those in the room, if you are registered to speak to the public, please make sure that the light is on the microphone before you speak. And when you leave the podium, to make sure that you push the mute button to make sure the light is off before you leave, as I'm about to do right now. Good morning, everyone. Mic check, 1, 2, 3. Commissioner, can you hear us?
Unclear.
Awesome.
We're cleaning our reading glasses. That's how old we are right now. Bobby, can you hear me? Great.
Thanks. Loud and clear. Ready when you are.
Bobby, we're going to be passing in planes because I'm coming to Santa Fe later. So we're going to be going like this.
I was just having that same thought.
Good morning and welcome to the April 3rd, 2025 meeting of the Texas Commission on Environmental Quality. This is why I had to clean my reader scale, 9:35 a.m. I'm joined by my colleagues, Bobby Janeka, who is in Santa Fe right now, giving a speech, and Katarina Gonzalez, our General Counsel, Mary Smith, and our Public Interest Counsel, Garrett Arthur. For each item that argument or discussion is allowed, we will inform parties and the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please either visit our registration table if you're here in person, or if you are on the webinar, email agenda@tcaq.texas.gov with your name, affiliation, and the item you would like to comment on. We will always do our best to accommodate your request. For those making presentations, please wait to begin your presentation until I've asked you to begin speaking. And please check to make sure that your line is unmuted before proceeding. Before we get to the first item, I'd like to say a little thing of gratitude. Gratitude's a really big deal to me as a leader and as a chairwoman. And I don't think we often thank these people enough, but our senior advisors for the commissioners are integral to our success as board members. So I would like to say thank you to Patrick Lopez, to Jesse Powell, who's Katarina's SA, and to Krista Kyle, who is Commissioner Janeka's SA. They are the best in the business, and we are so lucky to have them. They are who most of y'all end up interfacing with, because you have things that are coming before us, so we can't talk to you. So they are our eyes and ears and brains. So thank y'all very much. All right, Mary, first item.
Item number 1 is the consideration of the proposal for decision and proposed order concerning the application by Schreiber Foods Incorporated for a major amendment of TCEQ permit number WQ 0030740000. The parties have been notified that the applicant, the protestant, the ED, and OPIC will each have 5 minutes of oral argument time. The applicant should speak first and may reserve a portion of its time for rebuttal, as the applicant bears the burden of proof on this matter. And I believe first up would be the applicant, and I think we have Mr. Bradbury signed in virtually to speak for the applicant.
Good morning, Chairman and Commissioners. Jim Bradbury on behalf of Schreiber Foods. I'll reserve just 1 minute for rebuttal, but briefly, Schreiber Foods is a national food manufacturing company that primarily focuses on dairy products. This permit relates to a facility in Stephenville, Texas. It's been in operation for decades there. They manufacture cream cheese, yogurt, and some beverages. This is an application for a major amendment because they had a increased demand for their products, and they needed to slightly increase their production capacity. Technically, what it requested is approval to expand the application acreage from 50 acres to 61, increase the flow, and then update the BOD and total nitrogen. There was one issue identified by the commissioners back early. This permit was filed back in February of 2023. The commissioners identified one issue in relation to a protestant who lives nearby regarding whether the permit was protective of nuisance quality odors. ALJ Hunziker conducted a pre-hearing. We filed the application and the supporting materials, setting up the presumption in favor of protective of nuisance quality. As we proceeded, everyone filed their pre-filed testimony, including the executive director, which also supported that the permit was protective of nuisance quality conditions. In addition, we had 2 experts and 2 members of the company who put in testimony in support of the permit. We filed a motion for summary disposition before ALJ Hunziker, and there was no evidence put in by the protestant to rebut that. And so the ALJ issued a PFD in favor of the permit that it was protective of nuisance quality odors. Notwithstanding that motion, there was substantial evidence introduced by the ED as well as the applicant regarding the specific provisions of the permits and the practices of Schreiber Foods to reduce or potentially eliminate nuisance quality odors to the adjacent acreage. So we support the PFD. There were no exceptions filed by any party to that PFD, and we would ask the commission to approve the PFD and grant the permit. That's all I have. Thank you.
Thank you, Mr. Bradbury. The protestants, please. I think it's Ms. Tandy Remy.
And I will say that nobody has registered on behalf of the protestant. I see nobody getting up in the audience.
All right. 1 minute. Yep. All right, ED staff, please.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. I'm Allie Swallow with the Environmental Law Division. With me today are Thomas Starr and Greg Easley with the Water Quality Division. The Executive Director supports the ALJ's conclusion on the referred issue. The ALJ found that the uncontroverted evidence shows that the draft permit contains sufficient provisions to prevent nuisance odors. Therefore, in the absence of any evidence that the draft permit violates a specifically applicable state or federal requirement, the ALJ recommended that the Commission issue the draft permit and adopt all findings of fact and conclusions of law contained in the proposed order. The Executive Director agrees with the ALJ and respectfully recommends that the Commissioners adopt the ALJ's findings of fact and conclusions of law, grant the application, and issue the draft permit. Thank you, and we're available for questions.
Thank you. Any questions? OPIC, please.
Good morning. Chairwoman, Commissioners, Executive Directors, Attorney, and staff. For the record, I'm Jessica Anderson with the Office of Public Interest Counsel. In this matter, the ALJ granted applicant's motion for summary disposition and recommended that the draft permit be issued. OPIC is in agreement with the ALJ's recommendation. The Commission referred a singular issue, that of nuisance odors, to SOA for a contested case hearing. After considering the pleadings, evidence, and applicable law, the ALJ granted the applicant's motion for summary disposition due to the lack of evidence rebutting the prima facie demonstration on the referred issue. Indeed, no evidence was presented to rebut the prima facie demonstration that the draft permit contains sufficient provisions to prevent nuisance odors. For these reasons, OPIC agrees with the ALJ's recommendation that the Commission adopt the proposal for decision and issue the draft permit. Thank you, and we are available for any questions.
Thank you, Jessica. Mr. Bradbury, I believe you have 2 minutes and 27 seconds remaining for your rebuttal if you wish to take it.
Commissioners, I concur with ED and OPIC. I have nothing further, and I'll give you two minutes back in your day.
I could use those 2 minutes. Thank you very much. I'm in full agreement with how the ALJ handled the case and recommend the Commission adopt ALJ's order. I agree that the protestant provided no meaningful challenges to the prima facie demonstration of the administrative record that established at the preliminary hearing and that no party pre-filed testimony by the deadline regarding the referred issue. So I would issue the amended permit to the applicant and adopt the ED's response to comment. Commissioner Gonzalez, thoughts?
I'm in agreement.
Bobby?
Thank you for laying out your analysis, Chairwoman. I'm in agreement. I see it the same way.
Thank you. Do I have a motion?
I move that we adopt the administrative law judge's proposed order, issue to piece permit number WQ 003 00030740000 to Schreiber Foods, Inc. as recommended by the Executive Director, and adopt the Executive Director's response to comment.
Do I have a
Second the
second?
motion.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank you. Item number 2, we'll give everyone a little chance to shuffle around.
Item number 2 is the consideration of the application by R. Calling Incorporated for new TIPD's permit number WQ 00162-72001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Good morning again. Before us for our consideration is an application by R Calling Incorporated for a new TIPD's permit to authorize the discharge of treated domestic wastewater at a daily average flow not to exceed 900,000 gallons per day in the final phase. For hearing request matters, we have a two-part analysis. First, we review hearing requests to determine whether they meet the substantive and procedural requirements to be considered an affected person. If there are affected persons, we turn to the issues raised to determine if the scope of the hearing at SOA. We received hearing requests raising several concerns, including water quality, anti-degradation, notice, accuracy, and completeness of the application, and experience and expertise of the applicant. First, I'll discuss Ellis County. Based on the location of the proposed facility and the discharge route, as well as Ellis County's stated concerns and its statutory authority related to water quality within its jurisdiction under the Texas Water Code sections 26.171 and 26.173, I would find that Ellis County demonstrated that it is an affected person in this matter. I would also find that based on the location of the individual requester's property and the concerns raised by each requester, that the individual hearing requesters failed to demonstrate that they may be affected in a manner different than the general public. So I would grant the hearing request of Ellis County, deny the remaining hearing requests, and refer the matter to hearing with a concurrent referral to the Commission's ADR program on the issues concerning water quality, anti-degradation, the expertise required to operate the facility in accordance with Commission rules, and accuracy and completeness of the application in conjunction with applicable notice requirements. That concludes my thoughts. I'm happy to hear what Katarina and Bobby think.
I'm in agreement.
I reached the same conclusion.
Wonderful. Do we have a motion?
I move that we grant the hearing request of Ellis County, refer the application to SOA for a contested case hearing on the following issues with a concurrent referral to the Commission's Alternative Dispute Resolution Program. Issue A, whether the draft permit is protective of water quality, including the protection of the receiving waters in accordance with applicable regulations, including the Texas Surface Water Quality Standards. Issue B, whether the draft permit complies with applicable anti-degradation requirements. Issue C, whether the draft permit contains sufficient provisions to ensure the facility will be operated and maintained by sewage plant operators with the expertise required by Commission rules. And Issue D, whether the application is substantially complete and accurate and provides sufficient notice in accordance with applicable notice requirements. I finally move that we set a hearing duration of 180 days from the date of the preliminary hearing until a proposal for decision is issued.
I second.
Before, I wanted to confirm the remaining hearing requests. Based on the conversation, would you like to deny the remaining hearing requests as well?
Thank you. I do wish to deny the other hearing requesters. Thanks, Ms. Smith.
Second that motion.
All those in favor say aye.
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 The motion passes. Thank you. All right, let's go to item number 3.
Item number 3 is the consideration of the application by Cedar Creek MH LLC for new TIPD's permit number WQ0016303001. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
No one signed in. Before us, we have an application for a new TIPD's permit that would discharge up to 150,000 gallons per day of treated domestic wastewater. Let's turn to an effectiveness determination first. Similar to the previous items, I'll begin with my thoughts on who is eligible for a contested case hearing. The Commission received hearing requests from the Texas Department of Transportation and the Carr Family Partnership. For TxDOT, Texas Water Code Section 5.115B and 30 Texas Administrative Code Sections 55.103 prohibit TxDOT from qualifying as an affected person, so we are compelled to deny the hearing request. For the Carr Family Partnership, I believe that we should grant their hearing request. The partnership owns property alongside the discharge route in a very close proximity to the facility. It raises issues like water quality, nuisance odor, and regionalization that are relevant and material to the permit application. Therefore, I do believe that the partnership established a personal justiciable interest to qualify as an affected person. I'll stop there and ask my commissioners what they think.
I'm in agreement as well. I am sensitive to our sister agencies' comments on this permit, but TxDOT raised concerns related to the discharge route, specifically that it trespasses on TxDOT property. They note that it hasn't granted permission for the use of its right-of-way because of concerns related to the impact that additional water and the right-of-way may have had on the highway. And while TxDOT statutorily does not have a right to a contested case hearing, as the ED noted in her RTC, this permit would not supersede any authorizations that may be necessary from other agencies, including TxDOT, and the applicant would still be responsible for obtaining any necessary approvals for use of the discharge route. So it's not the same way.
Well said. And I believe we have someone from TxDOT in the audience today. Bobby, anything?
I want to offer my appreciation to our sister agency for offering what I believe are substantive comments, but I agree with your analysis and with Commissioner Gonzalez's that their participation would be outside the scope of what's allowed under the law and would find only the car partnership as an affected party.
Thank you, commissioners. Let's move on to the issues. Moving to the second part of our analysis on issues, as I mentioned, I believe the Carr family partnership raised issues related to water quality, nuisance odor, regionalization, human health, livestock, discharge route characterization, and whether the application is accurate. I believe these are all relevant and material issues that should be referred to SOA. Katerina?
I'm in agreement.
Bobby?
Likewise.
I agree with the ED and OPIC that 180-day hearing duration is appropriate, and I understand that the parties are already in touch with our mediation program and working towards a resolution. Well done. So no referral to ADR is necessary. Colleagues,
I'm in agreement.
do I have a motion?
I move that we grant the hearing request of Carr Family Partnership Limited, deny all remaining hearing requests, refer the application to SOA for a contested case hearing on the following issues. Issue 1, whether the draft permit adequately addresses nuisance odors in accordance with applicable requirements, including 30 Text Administrative Code, Section 309.13. Issue 2, whether the draft permit is adequately protective of water quality, human health, aquatic life, livestock, and wildlife in accordance with applicable regulations, including the Texas Surface Water Quality Standards. Issue 3, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code, Section 26.0282. Issue 4, whether the proposed discharge route is properly characterized in the application and will function properly as an operational feature of the facility. And Issue 5, whether the application is substantially complete and accurate. And further, that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second the motion.
Do I have a second?
I
Oh, second, sorry. All those in favor say aye.
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 Aye. Motion passes. Thank you. All right, we will move to item number 4.
Item number 4 is the consideration of the application by New Horizons Utility LLC and Opt-in Holdings 1 LLC for new TIPD's permit number WQ0016257001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those that have signed in will be noted for the record.
Good morning. Before us, we have an application for a new TIPD's permit that would discharge up to 1.34 million gallons per day of treated domestic wastewater in its final phase. We received hearing requests on this matter that were not withdrawn from the City of Georgetown and Ms. Beverly Wilkins. For hearing requests, we use the same two-part analysis as described in the previous items. Regarding effectiveness, which determines who has the right to a hearing, I agree with the ED and OPIC that the city of Georgetown is an affected person. The proposed outfall is immediately adjacent to the city's extraterritorial jurisdiction, and the 1.34 million gallons of treated wastewater will be discharged into the waterways that flow through the city's ETJ. The city identified its statutory authority over and interest in protecting the environment and public health, safety, and welfare within its jurisdiction related to this application. I believe that the city has demonstrated a personal justiciable interest in this matter, so I would grant the hearing request. For Ms. Wilkins' hearing request, since she did not file any comments during the comment period, we are compelled as a matter of law to find that she does not qualify as an affected person, so I would deny her hearing request. I'll stop there and turn to my colleagues.
I'm in agreement.
I agree.
Moving to the second part of our analysis on issues, the city raised relevant and material issues concerning regionalization, accuracy of the application, characterization of the discharge route, water quality, health, wildlife, nuisance odor, and associated buffer zone, notice, and compliance history. These issues are within our jurisdiction to consider for this type of application, so I would recommend that we send these issues to SOA. I would also recommend denying the request for reconsideration. I don't believe they raised new, relevant, and material information for the commission to consider that would not be addressed in a contested case hearing. Finally, I'd recommend 180-day duration and concurrent referral to TCQ's ADR program. Stop there. Commissioner Gonzalez,
I
Commissioner
agree.
Tedeka.
I'm also in agreement. Can offer that motion. I
Yes.
move that we grant the hearing request of the city of Georgetown, deny all remaining hearing requests and requests for reconsideration, refer the application to SOA for a contested case hearing on the following issues. A, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of regionalization under Texas Water Code, section 26.0282 and 26.081. B, whether the application is substantially complete and accurate. C, whether the proposed discharge route is properly characterized in the application and will function properly as an operational feature of the facility. D, whether the draft permit is adequately protective of water quality and the existing uses of the receiving waters in accordance with the Texas surface water quality standards, including applicable anti-degradation requirements. E, whether the draft permit is adequately protective of human health and wildlife. F, whether the draft permit adequately protects against nuisance odors and complies with applicable buffer zone requirements in accordance with 30 Texas Administrative Code 309.13E. And G, whether the applicant substantially complied with applicable notice requirements, and H, whether the draft permit should be denied or altered based on applicant's compliance history. I further move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts and set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Do I have a second?
Second?
All those in favor say aye.
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 The motion passes. Thank you. Go to item number 5. We'll give everyone a second.
Item number 5 is the consideration of the application by Harris County Municipal Utility District number 531 for new TIPD's permit number WQ0016334001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Thank you, Mary. Before us, we have an application for a new TIPD's permit that would discharge up to an average flow of 100,000 gallons per day of treated domestic wastewater in its final phase. Again, for these type applications, the commission considers a two-step analysis. First, we must determine whether a hearing requestor is an affected person. In this matter, the commission received timely hearing requests from 6 individuals. Darren Watley filed a timely comment and hearing request that identified his concern with the nuisance odor and impacts on wildlife. Mr. Watley provided information that he is located less than 1/10 of a mile from the facility, and I believe that he demonstrated a personal justiciable interest in the application. Turning to the requests of Madhu Sakaran and William Eli, I do not believe they have shown that they would be personally affected by this application in a manner that is different from the general public. They raised only general concerns in the requests, and to the extent that they raised specific concerns, those concerns were either not raised during the public comment period or were not within the jurisdiction of the commission to consider, such as property values. Finally, I agree with the ED and OPIC that Lisa Atkinson, Charlene Jones, and Laura Weathersby did not identify a personal justiciable interest in their request and therefore do not qualify for a contested case hearing. I'll stop there, see what Katarina and Bobby think.
I'm in agreement.
I'm in agreement as well.
Let's move on to the second part of our analysis on issues. Darren Watley raised relevant and material concerns about nuisance odor impacts on wildlife. These are relevant and material issues that the commission routinely refers to SOA, and I believe that we should refer these issues. I do not find that the request for reconsideration raised new relevant and material information for the commission to consider that would not be addressed in the contested case hearing. Bobby and Katarina?
I agree.
I also have on the other same two issues. Thanks.
Finally, I'd recommend a 180-day hearing duration as well as a referral to our ADR program. If we're in agreement, I will entertain a motion.
I move that we grant the hearing request of Darren Watley, deny all remaining hearing requests and requests for reconsideration, refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit is protective of wildlife in accordance with applicable regulations, including the Texas Surface Water Quality Standards, and B, whether the draft permit adequately addresses nuisance odor in accordance with 30 Texas Administrative Code, Section 309.13E, and that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and that we set a maximum hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Do I have a second?
I second.
All those in favor say aye.
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 Thank you. The motion passes. Item number 6, please.
Oh, there's no oral argument on 5.
Let him speak. Sorry, sir, what is your name? I believe our chief clerk informed you that there was no oral argument and no speakers allowed on item number 5. I understand that, but there was no oral argument allowed on item number 5. Would that go under public comment? Hold one second. I'm sorry, we've already voted on item 5, and we were notified all parties that there would be no oral argument and no public comment. I'm sorry about the online form. I haven't looked at it, but I will take a look.
I had 2 problems. One, a couple of miles away, another a mile. Very close in terms of not just loss of property values, but pollution and use of property. The general public doesn't use those trails like we do. So it's a very that much. It builds up. That's people that's action. So they try to eliminate all of my response. Looking at the legal distinction, it makes sense. Absolutely. It will be brought up in the litigation.
We're going to move on to item 6.
Item 6 is the consideration of the petition filed by Borework Farms LLC for the creation of Williamson County Municipal Utility District number 52. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Thank you. Item number 6 is a petition for the creation of a municipal utility district with road powers in Williamson County. Districts are handled slightly differently than hearing request matters for wastewater permits. For district creations, we look only at whether the hearing requestor is entitled to a hearing. Relevant today's hearing, TCEQ rules require the commission to consider for governmental entities their statutory authority over or interest in the issues relevant in the application. For this item, we received a single hearing request from Williamson County. The proposed district will be entirely located within Williamson County, and the county listed numerous statutes regarding various aspects of the development that it has statutory right over. In addition to the county's various public health and safety authorities under the Transportation Code, the county has broad authority over various aspects of roads. This application contains a request by the petitioner for road powers, which requires the commission to review the petitioner's cost analysis and the amount of bonds necessary for the road facilities and determine whether the road facilities are financially and economically feasible for the district. The county has raised concerns related to the roads within the district. The petitioner urges us to forego a hearing on this matter because the county will have an opportunity to approve its roads later. But I believe it's important to have this review earlier. It ensures that the planned roads and funding are feasible before the MUD moves forward and potentially saddles the future property owners with debt for roads that may not be approvable at the county level. Therefore, I would refer the county for a contested case hearing and refer the parties to our ADR program. Commissioners?
I have some questions for Williamson County if they're here today.
They haven't registered.
It's unfortunate. I also see that they didn't respond to the applicant's reply as well. I do have some concerns on Williamson County being an affected party. I have reviewed the ED's technical memorandum, the county's hearing request, and the petitioner's response. And based on those, I would deny the county's hearing request and grant the petition to create Williamson County MUD number 52 as well as grant the request for additional road powers. While our rules require us to consider whether a local government has statutory authority over interests relevant to the petition, I don't believe they require the commission to grant a hearing request based solely on such a description of that authority. Focusing on Williamson County's authority over roads within the county, I'm persuaded by the petitioner's point that the county will have the opportunity and indeed the authority to approve roads and aspects of roads that would affect the county when the petitioner submits plans for those roads. Therefore, I don't see a need for the commission to put all the parties to the expense of a resource-intensive contested case hearing and would deny the county's hearing request. I've also reviewed the ED's technical memorandum and other documents supporting the petition. I believe that the information shows that the proposed district is feasible, practical, and necessary and would be a benefit to the land to be included in the district. I would also approve the district's request for road powers and appoint Elizabeth Emmeline Hoft, Charles Edward Weatherby, Asa Lucas Rosales, Emily Rochelle Palacios, and Seth Wallace as temporary directors. And I further note that there are several standard provisions included in our district creation orders, so I would direct the Office of General Counsel to draft an order that incorporates all of those provisions.
Thank you, Commissioner. Commissioner Janeka.
I appreciate hearing those thoughts, Commissioner Gonzalez, and I think that's a worthwhile point of discussion and in consideration for future matters. I think in this particular instance, I reviewed the requests before us and I found that granting the hearing request for Williamson County would be appropriate and consistent with past decisions. So I would be in favor of sending it to SOA with the regular referral without issues attached, and the ADR referral as well.
Thank you, Commissioner Janeka. Do I have a motion?
I move that we grant the hearing request of Williamson County, refer the matter to SOA for a contested case hearing on the petition, and refer this matter to the Commission's Alternative Dispute Resolution Program, concurrently with the SOA preliminary hearing scheduling process.
All those in favor say aye. Oh, do I have a second?
You'll have to say.
A second. All those in favor say aye.
No.
Aye.
The motion passes. Thank you. All right, item number 7 has been continued to the May 22nd agenda. We will go through the enforcement docket at this time.
Okay, we'll give everybody a chance to get up and get situated. That takes us to the enforcement docket, items 8 through 35, and the executive director's staff is here to present these matters.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Amy Sedemeyer of the Enforcement Division, and with me today are Craig Pritzloff of the Office of Compliance and Enforcement and Katanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 8 through 35. The total assessed administrative penalties are $890,413, with $136,940 deferred, $279,730 applied towards supplemental environmental projects, and $469,016 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thanks, Amy. Mary, do we have anyone signed up in these items?
So I'll just acknowledge that on 8, 9, 11, 13, 18, and 21, we have individuals who are signed in and available to speak if the commission has questions. On item 13, we do have someone who has requested to speak, and I'm going to apologize because the name is unfamiliar to me, and I hope I don't slaughter it, but Vija Bean Subramaniam, and they're attending remotely.
Yes, I can hear you.
Yes. Do you have a comment, please?
Yes, good morning, everybody. I'm
Morning.
Vijay Subramaniam, and I was the one who was driving the truck, and somebody in a car came and hit my truck. It was back in 2021. Then I gave all the information to their TECQ. His name of their person was Williams Dorothy. She got all my information from the insurance company who hit my vehicle, which was insured, and they were taking care of everything. And ever since, I wasn't sure what's going on. And I was just checking the email when I got this letter saying that I had to be in Austin or do something about this meeting. So that's when I look at on the system on the email, and I was looking at it, and I found out that everything was handling directly with TECQ and the insurance company. So I wasn't sure what was going on. But if I had to pay for the money penalty, $2,600, I would pay for it out of my pocket. I don't mind. But if that's fair, if you all think that's fair that I had to pay for it for the report, I would pay for it. But I wasn't aware that they still haven't taken care of it yet. But I tried to contact the cleaning company who did the work, which I didn't do it. The city of Fort Worth is the one who called, had them come and do that. So they are the one who did all the work, and they're all handling directly from the insurance company and the party who cleaned it and everything. So that was nothing. Or another thing, I don't know if you can hear that, but the damage I have on my truck since 2021. That the insurance company, they sent a check for my damages, but I already paid for the truck, even though they put my name on it, which is my company name, and also they put the financing company name on the payment they sent me. And I called them, hey, I couldn't cash it because it's already been paid for it. So they said, hey, send the picture of the title and the lien holder release, and they will send another check. And it's still right now, we are in 2025, and I still haven't got the payment from that insurance company yet. The name of the insurance company is UAIG.net. So, if I had to pay for it, if you all think that's fair, I had to pay for it, I would pay it and then get away with it. Just let me know what you all want from me, and I will do whatever you want me to do.
Thank you for your comment.
You're welcome.
Edie, do you want to respond to that?
Good morning.
Morning.
My name is Geethanjali Yadav with the Litigation Division. So this item before you is a default order. So the sole issue is whether respondent had proper notice of the order. There was no hearing request made in this matter, despite numerous attempts by staff to reach out to respondent and let him know his options. This is an LLC, and Mr. Subramanian is listed as the registered agent and the member. And so that was using the address on file with the Secretary of State. We mailed the petition to Mr. Subramanian via certified mail on June 7th, 2023. We refiled because it was not deliverable as addressed. We refiled on August 8th, 2023, and again on September 12th, 2023. We sent that via certified mail and first class mail in accordance with our rules. It was not deliverable as addressed, but the SOS by the Business Organizations Code is an agent of service for an LLC. And so we served the petition on the Secretary of State, and they certified service on June 14th, 2024. In addition to that, we make other efforts to reach out. And so we tried to call the respondent on October 17th, 2023, and again on August 1st, 2024, after service was sent by the Secretary of State. We tried to contact them, left a message about the options to either settle, or if settlement could not be reached, to file an answer, and that a default would be issued if an answer was not filed. No answer has been filed. We also sent a 10-day letter, which we do in all of our cases before agenda, where we let them know they have 10 more days, otherwise a default order will be issued in this case. And that was sent on February 7th, 2025.
Thank you very much. So all notice requirements were followed to the letter of the law, and it sounds like you actually went above and beyond trying to reach.
Correct.
Any questions? Bobby?
I had a question. I'm I'm curious about the underlying permit that our agency issues for this as the basis for the industrial hazardous waste enforcement order that we've got before us as a default. Did litigation or any of our folks on the enforcement side of the agency consult with any of the permitting side of the agency associated with that underlying permit to try to confirm and verify contact info? I'm hearing a very good explanation of our thorough notice, fully noticing parties and going through that process is something we follow very well. I don't think that always fully accomplishes the engage meaningfully with the public expectations that we have, where I'm hearing a small business owner here, a small member of public is experiencing difficulties hearing from us at all. Do we have any contact info for Mr. Subramaniam for the underlying permit? And did we have any efforts to connect with staff who deal with them on that side?
Well, it was it was a company. I received a letter from. It says name of the company was Cleaning Guys. That's the name of the company, and they were the one who did the work. And I got after I received the letter, I left a voicemail, and somebody else called me back, and they say they bought the company from Cleaning Guys, and they don't have any. They see the case number on there, but they don't see any of the reports or nothing on there. They don't they don't have any other information other than their report number on it. So I asked them, hey, can you just release me the report so I can send it? So because I don't know the rules, but if I have to send it, I will send it, So that I asked them, and then they said, hey, we have to dig into it and see how, how we can get it. It's been like over 4 years, a little over 4 years, and they don't have any other information on the system other than the report number. I said, I told them, hey, the TECQ is really requesting for the report only, nothing else other than the report, just at a summit. So other than that, they said, hey, we will try to see if we can get that, since they were a new company, bought everything from them, and they don't have any other report from the old company, which calls Cleaning Guys. So, but like I said, TECQ, they have directly contact. I connected the TECQ and the Cleaning Guys together, and the TECQ was the one contacting the Cleaning Guys when they were in business. So after that, I wasn't aware of anything, But like I said again, if you all think that is fair, I had to pay for it, then I will pay for it. Just make a decision, let me know, and if I have to, I will. That's what I'm saying. I don't have any other thing. I mean, I'm not against with anybody. If I really had to pay for the fine and get done with that, I would pay for it. I'll send a check or whatever. Yeah, thanks.
Thank you, Mr. Subramaniam. I appreciate that, and I have since been notified or reminded this is concerning a spill, and so I was a little mistaken in assuming that there would be a specific underlying authorization from our agency. So I think I can better understand now why.
Yeah, it was just a diesel fuel on the side of the street.
Thank you. Thank you, sir. I appreciate it. Could I hear from Executive Director staff now, if they have anything to add to this?
Yes, thank you, Commissioner Janetka. I'm Craig Pritzloff, Director of the Office of Compliance and Enforcement. Madam Chair, Commissioners. This is an event that occurred in April of 21. It was an accident. Approximately 75 gallons of diesel fuel was spilled. We were in direct contact with the president of the company on multiple occasions prior to issuing an NOV in December of 21. We issued several extensions in the months preceding that, between April and December of 21, trying to get the final cleanup report. We understand cleanup was conducted. We just need a final report. As the respondent was just noting, he can get that from cleaning company. After the NOV was issued, they failed to respond and provide the report. We gave them several opportunities to respond on that. Ultimately, a notice of enforcement was issued. And then you heard from our Director of Litigation Services, because this matter was then referred over to there because of just non-responsiveness to provide that report. We tried. We're here now. I hear that he's got the report. That's all he needs to do, and then pay the administrative penalty. Thank you.
Thank you. Commissioner Janetka?
I have no further questions. I appreciate that information. Mr. Pritzloff.
Thank you. Commissioner Gonzalez? OPIC, Garrett?
Good morning, Chairwoman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. Regarding items 8 through 35, OPIC has reviewed each of these enforcement items, and we support adoption of all the orders presented by ED staff.
Thank you, Garrett. I'd like to thank staff for their work to bring these items before us today. I've reviewed them all, and I am ready to move forward with them. Colleagues?
Same.
I'm ready as well.
I'll entertain a motion.
I move that we adopt items 8 through 35 as recommended today by the Executive Director.
Do I have a second?
Second
All those in
motion.
favor say aye.
Aye.
Aye. Excellent. Thank y'all. Right, item number 36, please.
Item 36 is the consideration for publication of and hearing on the proposed Collin County second 10-year maintenance plan SIP revision for the 2008 lead National Ambient Air Quality Standard, and the Executive Director staff is here to present this matter.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Eugenia Reynoso with the Air Quality Division. With me are Allison Stokes with the Air Quality Division, and available online is Contessa Gay with the Environmental Law Division. For your consideration today, it's item 36, the Executive Director's proposed revision to the State Implementation Plan, or SIP, to provide a second 10-year maintenance plan that ensures the Collin County area remains in attainment of the 2008 lead National Ambient Air Quality Standard through 2037, as required by Section 175A, subsection B of the Federal Clean Air Act. Staff respectfully request permission to publish the proposed SIP revision, solicit public comment, and hold a public hearing. Thank you for your consideration. We are available to answer any questions.
Thank you so much. Do we have any interested persons?
One is signed in on this one.
Okay. OPIC?
Good morning, Chairwoman, General Counsel, Commissioners, and Executive Director. My name is Eli Martinez, and I'm with the Office of Public Interest Counsel. For the record, we've reviewed the proposal of the Collin County second 10-year maintenance plan, state implementation plan revision, and we recommend that the Commission approve this item as proposed by the Executive Director. We are happy to see that the area surrounding the former Exide Technologies plant in Frisco, Collin County is now in attainment with the 2008 lead NACs, and that submission of this plan will ultimately fulfill any requirements to the EPA to avoid a potential finding of a failure to submit. And for these reasons, we support approval.
Thank you. I'd first like to thank staff again for their work on this proposed SIP revision. I reviewed the 10-year maintenance plan, and I'm ready to move forward and put the proposed SIP revision out for publication and public comment. Commissioners?
I'm in agreement.
You know what OPIC said.
Do I have
I
a
would
motion?
I move we approve the publication of and hearing on the proposed Collin County second 10-year maintenance plan, state implementation plan revision for the 2008 lead National Ambient Air Quality Standard as recommended by the Executive Director.
Do I have a second?
Second.
All those in favor say aye.
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 Thank you. Thanks, y'all. Item 37 is public comment.
The Commission will receive comments from the public on matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112, except for pending permit matters or other contested cases, which are subject to the ex parte prohibition found in Texas Government Code Section 2001-061. In the interest of time, speakers will be limited to 3 minutes each, with the total time for public comment limited to 1 hour. Please note that the Commission's discussion of subjects for which public notice has not been given is limited to statements of specific factual responses and recitation of existing policy. We have one person signed in for the public comment session, Mr. Errol Summerlin, who is virtual.
Mr. Summerlin?
Yes, can you hear me?
We can hear you.
All right. Well, good morning, commissioners. We're not going to argue anything today, okay? My name is Errol Summerlin. I lived in Portland, Texas for 40 years, but have now relocated to the state of Maryland. I'm also a co-founder of CAPE. I'd like to comment on SOA's administrative law judges and the proposals they send to you. When you refer a proposed permit to SOA for a contested case hearing, an administrative law judge is assigned. More often than not, two are assigned. Now, I don't know how these cases are assigned, what qualifications are required to be a SOA judge, or if there are special qualifications required to hear matters referred from the TCEQ. My own experience as a protestant at contested case hearings and doing a little research on other proposals for decisions that have been rendered, the judges hearing these cases are consistently the same judges. One was licensed to practice law in 1986, the other in 1999. These are not inexperienced attorneys. They are seasoned, well-versed in the applicable law, rules, and regulations governing the TCEQ's authority, its limitations, and processes. Over the course of 6 to 9 months, these judges hear witnesses and expert testimony, receive briefings, review numerous exhibits, and hear from all parties on applicable statutes, rules, and regulations. The judges then issue a proposal for a decision, taken literally, saying to you, we looked, listened, and examined the arguments, and here's the way you should decide the matter. Protestants rely on this process. It's their day in court, and they anticipate their arguments and evidence will be fairly and impartially reviewed. But doing a little research, looking for trends of the Commission's actions on these proposals, we found that in every instance where the PFD recommended denial of a permit to a heavy industry, you dismissed that recommendation and granted the permit as drafted by the ED, or you altered the judge's findings of fact or conclusion of law and then granted the permit. The proposals are often altered to comport with your interpretation of state statutes and rules and TCEQ rules. We also see the commissioners frequently altering findings of fact for greater accuracy or alignment with your own interpretation of the evidence in the administrative record. So you read the administrative record and come to your own conclusion, an opinion that outweighs the rigorous due process given all parties to arrive at the judge's proposal. You need to accept these proposals these judges make, especially when OPIC concurs. I know it's a two-way street. I was a protestant on item number 1 last month, and I had to accept that we did the best we could, and the judges didn't agree with us. We'll just take it from there. But your pattern of routinely siding with heavy industry permit applications is an affront to those living in the shadows of these facilities. I want to thank you for your time today, and y'all have a great day. Thank you.
Thank you for your comment, Mr. Summerlin. Is there anyone else signed up for public comment?
No one else.
Would anyone like to wish to address the board at this time? All right.
So that brings us to items 38 through 41, which are for closed session, but the commission will not be meeting in closed session today.
The agenda stands adjourned. The time is 10:34 a.m. Thank you.
Thanks all.